Prayer to Saint Michael the Archangel. Saint Michael the Archangel, defend us in battle, be our protection against the wickedness and snares of the devil. May God rebuke him, we humbly pray, and do thou, O Prince of the heavenly host, by the power of God, cast into hell Satan and all the evil spirits who prowl about the world seeking the ruin of souls. Amen.
Review Notes in Evidence. Sa isang aralin tungkol sa criminal evidence sa Pilipinas batay sa Revised Rules of Court, matututunan mo kung paano pinapatunayan ang kaso sa korte. Saklaw nito ang mga panuntunan kung anong ebidensya ang katanggap-tanggap, admissible, gaano kabigat ang kailangan at paano ito ipinapakita. What is evidence? Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Ang evidence o ebidensya ay anumang impormasyon, bagay o pahayag na ginagamit upang patunayan ang isang katotohanan o suportahan ang isang paniniwala. Ito ang nagsisilbing basehan para malaman kung totoo o hindi ang isang pangyayari. Ito ay kilala bilang ebidensya, katibayan o patunay. Concepts of evidence. 1. It is a means of ascertainment used to arrive at a legal conclusion. 2. It is sanctioned by the rules of court, meaning not excluded by the rules on relevancy and admissibility. 3. It is used in a judicial proceeding. There is a jural conflict involving different rights asserted by different parties. 4. It pertains to the truth respecting a matter of fact. Evidence represents a claim either for the prosecution or for the defense where issues, clashes of view are present. Importance of the study of evidence in law enforcement. Bilang bahagi ng ating criminal justice system, tungkulin ng bawat ahensya ng nagpapatupad ng batas, law enforcement agencies, na ibigay sa taga-usig, prosecution, ang mga materyales at impormasyon, ebidensya, na kinakailangan upang mapagtibay ang paghatol. Ang bawat tao ay may karapatang ituring na walang sala sa isang krimen o pagkakamali, maliban na lamang kung mapatunayan ang kabaligtaran. Ito ay isang prima facie na pagpapalagay na dapat madaig ng patunay na lampas sa makatwirang pag-aalinlangan, proof beyond reasonable doubt, connecting the chain of events through evidence during trial. Ang paglilitis, trial, ay ang pagsusuri sa harap ng isang may kapangyarihang hukuman alinsunod sa batas ng bansa ng mga katotohanang pinagtatalunan sa isang kaso upang malutas ang nasabing usapin, U.S. versus Raimundo, 14 na Phil 416. Ang ebidensya naman ay nakakatulong sa pagtukoy ng mga tanong ukol sa katotohanan, questions of facts, sa pamamagitan ng pag-alalay sa hukom na buuin muli ang sunod-sunod na pangyayari mula sa pagkakabuo, conception, hanggang sa maisakatuparan, consummation, ang isang planong kriminal. Factum probandum and factum probans. Factum probandum, the ultimate facts to be proven. These are the propositions of law. Examples: murder was committed through treachery, robbery was made through force upon things. Factum probans, the evidentiary facts. These addresses questions of fact. Examples: exit wounds were in front, indicating that victim was shot at the back, destroyed locks, indicative of force upon things. Proof and evidence. Ang ebidensya ay ang instrumento o pamamaraan upang makarating sa isang konklusyon. Sa ilalim ng Revised Rules on Court, ito ay binibigyang kahulugan bilang ang mga pamamaraan na pinahihintulutan ng mga patakaran para matukoy sa isang paglilitis sa hukuman, judicial proceeding, ang katotohanan ukol sa isang usapin ng katotohanan, matter of fact. Katibayan/patunay, proof. Ang patunay ay ang resulta ng paghaharap ng ebidensya. Ito ang pagbuo ng kinakailangang antas ng paniniwala sa isip ng huwes patungkol sa mga katotohanang pinag-uusapan. Tumutukoy ito sa pagtitipon ng mga ebidensya na sapat upang makumbinsi ang hukuman. Quantum of evidence, the totality of evidence presented for consideration. Quantum of proof refers to the degree of proof required in order to arrive at a conclusion. Burden of evidence, the duty of a party of going forward with evidence. Burden of proof, the duty of the affirmative to prove that which it alleges. Variations on degrees of proof based on type of action, Isang kasong criminal action, proof beyond reasonable doubt, antas ng ebidensya na nagdudulot ng paniniwala o katiyakan sa isang kaisipang walang kinikilingan. 2. Kasong civil action, preponderance of evidence, ebidensya na mas mabigat o mas kapanipaniwala kaysa sa iniharap upang pasubalian ito. Kasong 3. Administrative action, sufficiency of evidence/substantial evidence, dami ng may kinalamang ebidensya na maaaring tanggapin ng isang makatwirang pag-iisip bilang sapat upang bigyang katwiran ang isang konklusyon.
Evidence illegally obtained are inadmissible for reasons of public policy. This is so because of the constitutional requirement of due process. Due process has been defined as the law that hears before it condemns, which proceeds upon inquiry, and renders judgment only after fair trial. As a result, jurisprudence has evolved a rule that renders inadmissible any evidence obtained in an illegal search from being introduced in trial. The fruit of the poisonous tree doctrine is a law that makes evidence that was obtained illegally, for example, through illegal searches, unacceptable or inadmissible in court. If a law enforcement agent conducts an illegal search and collects evidence of a crime, the doctrine forbids the use of that evidence in court, as well as any evidence found legally, if it stemmed from the illegal search. The fruit of the poisonous tree doctrine is important because it prevents prosecutors from using evidence that was collected through illegal means. It also discourages law enforcement agencies from engaging in illegal or reckless behaviors as a way to collect evidence. Example 1. A police officer enters into a house to search for evidence without probable cause or a search warrant. The officer finds illegal drugs and arrests the owner of the house. The officer also seizes money that the owners of the house had in their possession. During the court case, the judge rules that the officer violated the Constitution and searched the house illegally. The case was dismissed because the only evidence of a crime was collected illegally.
Admissibility of evidence. For evidence to be admissible, it must be 1. Relevant to the issue relevancy test, and 2. Not excluded by the law or rules of court competency test. Note: to determine the relevancy of any item of proof, the purpose for which it is sought to be introduced must first be known. There must be a formal offer. Question: is the printout of a photograph from your mobile phone showing a fly in the soup you ordered admissible evidence in an action for damages against the restaurant owner? What's your answer?
Admission and confession. In legal terms, all confessions are admissions, but not all admissions are confessions. Under the rules of court on evidence, the two terms are distinguished primarily by the scope of the acknowledgement. Admission and admission is a voluntary acknowledgement or statement of a relevant fact that goes against a party's interest, but it does not directly acknowledge full guilt. Scope, used in both civil and criminal cases. Key concept, it only admits a specific piece of the puzzle, leaving other elements to be proven. Confession. A confession is a specific type of admission where the accused explicitly and directly acknowledges guilt for the crime charged. That is, I committed the crime. Scope, used only in criminal cases. Key concept, it admits to all essential elements of the offense. Best evidence rule. When the subject of the inquiry is the contents of a document, no evidence shall be admissible other than the original of the document. For exceptions, see Sec. 3 Rule 130, Revised Rules of Court. A document is legally considered original when 1. It is the subject of an inquiry. 2. When in 2 or more copies executed at or about the same time with identical contents. 3. When an entry is repeated in ordinary course of business, one being copied from another at or near the time of the transaction.
Secondary evidence. When the original document has been 1. Lost, 2. Destroyed, or 3. Cannot be produced in court. The offerer without bad faith must 1. Prove its execution or existence, and 2. Prove the cause of its unavailability. Secondary evidence may consist of 1. A copy recital of its contents in some authentic document, or 3, by testimony of witnesses. When original document is in the custody of one adverse party must have reasonable notice to produce it. After such notice and satisfactory proof of its existence, he fails to produce it, secondary evidence may be presented. 2. Public officer, contents may be proved by certified copy, issued by the public officer in custody thereof. Testimonial evidence. Qualifications of witnesses. 1. Can perceive. 2. Can make known their perception to others. 3. Not disqualified by reason of mental incapacity, immaturity, marriage, privileged communications, or dead man's statute. Res inter alios acta rule. General rule. The rights of a party cannot be prejudiced by an act, declaration, or omission of another. Exception. 1. Admission by a co-partner or agent. 2. Admission by a conspirator. 3. Admission by privies. 4. Admission by silence. General rule. A witness can testify only to those facts which he knows of his personal knowledge, that is, which are derived from his own perception. Any statement which derives its strength from another's personal knowledge is hearsay, and is therefore inadmissible. Exceptions. 1. Dying declarations, ante mortem statements. 2. Declaration against interest. 3. Act or declaration about pedigree. 4. Family reputation or tradition regarding pedigree. 5. Common reputation. 6. Part of the res gestae. 7. Entries in the course of business. 8. Entries in official records. 9. Commercial lists and the like. 10. Learned treatises. 11. Testimony or deposition at a former proceeding. Presentation of evidence. The examination of witnesses presented in a trial or hearing shall be done is open court, and under oath or affirmation, unless the witness is incapacitated to speak, or the question calls for a different mode of answer, the answer of the witness shall be given orally. Rights and obligations of witnesses. 1. To be protected from irrelevant, improper, or insulting questions, and from harsh or insulting demeanor. 2. Not to be detained longer than the interest of justice requires. 3. Not to be examined except only as to matters pertinent to the issue. 4. Not to give an answer which would tend to subject him to a penalty for an offense, unless otherwise provided by law. 5. Not to give an answer which would tend to degrade his reputation, unless it be to the very fact at issue, or to the fact from which the fact in issue would be presumed, but a witness must answer to the facts of his previous final conviction for an offense. Classes of documents. Documents are either public or private. Public documents are 1. The written official acts or records of the official acts of sovereign authority, official bodies and tribunals, and public officers, whether of the Philippines or a foreign country. 2. Documents acknowledged before a notary public except last wills and testaments. 3. Public records. 1. Kept in the Philippines, or private documents. 2. Required by law to be entered therein. All other writings are private. To summarize, evidence in court proceedings is governed by specific regulations designed to establish the truth of a factual matter. To be admissible, evidence must be relevant to the case and not excluded by law. The burden of proof typically lies with the party making the allegation, requiring a specific quantum of evidence, such as preponderance of evidence in civil cases or proof beyond reasonable doubt in criminal cases. Original documents are generally required, though established exceptions allow the use of secondary evidence. Finally, witnesses must be competent and testify based on personal knowledge rather than hearsay.